Lord, turning to the second ground of appeal, which relates to the proper construction of the prevention of access and enforced closure clauses. It's a short point on which the judge gave permission. Can I perhaps just start by going back to the relevant clauses? Supplemental Bundle 1, page 7.
Yes.
And Lord, if we go back to 2.3.8, notifiable, well, perhaps if we start, actually, it's easier with 12, prevention of access, non-damage, during the period of insurance where such interruption or interference is for more than 8 consecutive hours. And we go to the definition of prevention of access, which is at definition, which is on page 30. Definition 87. Prevention of access, non-damage means, and in our context too, the actions or advice of the police, other enforcement agency, military authority, governmental authority or agency in the vicinity of the insured locations, which prevents or hinders the use or access to insured locations during the period of insurance, and perhaps underlining there the during bit of during the period of insurance. And if we go back again to the policy definitions on page 7, and look this time at 8, notifiable diseases and other incidents, and we then look at the definition of notifiable diseases, and we can look at the definition at page 29 for these purposes because it's easier to read.
Yeah.
We see there under 5, which your Lordship's seen, defective sanitation or any other enforced closure of an insured location by any governmental authority or agency or a competent local authority for health reasons or concerns. And if one then goes back to 2.3, 8D, one sees that is finished off with then one of the sub-requirements, and in this case occurring within the vicinity of an insured location during the period of insurance. So it's a short point of construction. We say the language used makes clear that the prevention of access is only covered if it prevents or hinders the use of access to insured locations during the period of insurance. And in the context of enforced closure, it's only covered if it's an enforced closure of an insured location during the period of insurance. So the scope of the indemnity is limited to covering the prevention of access or enforced closure during the period of insurance. And in this context, during, we say means, has its normal meaning of within a set period of time. There is no cover, we say, for enforced closure or prevention of access outside the period of insurance, or for enforced closure or prevention of access which starts within the period of insurance but continues after. All that is covered are losses proximate to the prevention of access or closure within the period of insurance. And those, of course, there may still be losses that occur within the maximum indemnity periods, start-up costs of having been closed. The business may have gone under because of the closure, so there may be long-term consequences. But what's not covered is the mere fact that the closure continues for longer. And we say that interpretation is a straightforward and natural reading of the words.
Prevention of access occurs, does it not, during the period of insurance? I mean, even in the case where it's it starts on the 27th of September 2020 and continues thereafter.
Well,
it's occurred on the 27th of September 2020.
Well, my Lord, that's the question, therefore, what we'll say the initiating event, because that's what the judge said. The judge focuses on the initiating event.
The judge relied on the definition of indemnity period, didn't he?
No, but my learned friend does.
Yeah.
But I'll come to the indemnity period definition, if I may, afterwards. Okay. Because we say the indemnity period is dealing with a separate question, not the question of the scope of cover, but the scope of cover for the consequences of what is covered, which is a different question. Because there's a distinction between cover for things which have occurred during the period of insurance, so the closure during the period of insurance, and that continues during the maximum indemnity period, and saying that the closure after the period of insurance is itself covered.
If for the sake of argument, you had a prevention of access on the 1st of September, on your case, there's only cover for 27 days, even if it continues until the end of the indemnity period.
Yes, what you'd have covered afterwards are the consequences of the 27 days.
Consequences of the 27 days.
Yes.
If in fact it's closed for the next 18 months, you can't recover for any of that at all.
That would not be under the scope of this clause. Yes, that's the short point of construction. And the reason we say that is because the language, we say, is clear on this, because it refers to preventing or hindering the use of the insured indications during the period of insurance. That's what's being the scope of cover, which is being referred to. Now, as your Lordship's indicated, the judge found that the clause that provided cover for imposed closure outside the period of insurance, but within the maximum indemnity period, as long as the relevant enforced closure or prevention of access commenced during the period of insurance. And he deals with this at paragraph 67 of the judgment, and that's it, core bundle, tab 15, page 257. And we say that
which paragraph?
67.
Thank you.
Now, Lord, we say that conclusion is wrong on the wording because it's inconsistent with the reference to cover being during. It requires the manipulation of the wording by reading in the word essentially beginning or commencing or starting with instead of the word during the period of insurance. And in simple terms, that is not what clause 2.38 or 2.312 says.
It is consistent with the language, isn't it?
Well,
I mean, it has to be something that happens as a result of X occurring during the period of insurance.
Well,
so if X occurs during the period of insurance, that is one interpretation of the language.
Well, in my submission, it's not in circumstances where it is defining the prevention of access, which is a state of affairs, not a beginning. What is a beginning is the other elements of the composite peril, such as the government advice or the discovery of a bomb. That's the beginning, that's initiation, but that's not what the clause is actually referring to. The clause is defining, and prevention of access is the most obvious, but you'll say prevention of access is what has to be during the period of insurance. But even if one were to say, well, maybe one could look at it that way, it's inconsistent with how the policy in the same clause deals with other insured events. So, my Lord, if one turns to back to the policy definitions, or sorry, the policy insuring clause at 2.3, which is on page 7 of the first supplemental bundle, your Lordships can there see that in the context of 2.32, Food Safety Act investigations, it refers to investigations commenced during the period of insurance. in the context of 2.36, investigations of crimes and incidents, it again talks about incidents which have commenced during the period of insurance, where such interruption or interference is for more than 4 hours. And in the context of loss of attraction, 2.37, it talks of a loss of attraction which commenced during the period of insurance. And we do say that that is a firm indication that the natural implication that we seek to derive from the wording is right, because where the draftsman intended to do something different, he or she said so by using the word commence. We could have used the word beginning, as opposed to something which appears to define it by reference to the scope of the prevention of access within the relevant period.
Well, both food safety investigations and investigation of crimes and incidents are investigations which extend over a period, and it may be that you don't know until the end of the investigation whether it's going to have any consequences for your business, but nevertheless you know you're being investigated. So are they really comparable?
Well, we would say that they're potentially, I mean, certainly at the start of prevention of access, you don't know if it's going to continue, as in the very start, because it needs to extend for more than a certain number of hours.
But you know that you're closed.
You know there's prevention of access. Yes, well, that's right. I mean, I think it's right. If one looks at the food safety investigations definition, and perhaps one should just do that for...
Where's that?
And that's at page 26, paragraph 37.
Yeah.
It actually means the inspection and seizure of suspected food by a competent authority, where the food is subsequently determined to be in compliance with food safety requirements. So it does actually, in that case, require an act of seizure to have taken place. And of course, there's also the loss of attraction one, which on any event is such an argument which applies. So the point we're making is, I mean, your Lordship has my point about the initial wording, and then we're saying, well, if you test it, is this simply that the draftsman, in what is a carefully drafted, detailed policy, using loose language? Well, we say the suggestion is not, because where there is the reference to a beginning of a point of time within the during, that is expressly stated, whereas in these two clauses, the scope of closure or the prevention of access is defined by reference to the period of the policy, during the period of the policy, a beginning and an end. The other difficulty with it, we say, is that it treats the initiating government action or advice alone, or the beginning of the exercise, as the insured peril, as opposed to each of the elements which need to be satisfied in the clause. Namely, for example, on prevention of access, that it needs to be during the period of insurance with the actions or advice of the police which prevents or hinders the use of access. It's all three elements. As the Supreme Court confirmed when they looked at the hybrid clauses in the test case, you need to look at the interconnected elements of the composite peril happening in causal sequence. And simply taking out one point, the beginning of it, or the initiating government advice, or the enforced closure by the health authority, we say it is misplaced and ignores the fact that the peril also includes the prevention of access, which itself is defined as something which occurs during the period of insurance. So this is a case where the insuring clause itself has defined its scope.
Could you just elaborate a bit on what difference your construction makes? Because you say that you have cover for the consequences of a prevention of access which begins during the period of insurance, but if the government closes you down on the 1st of September and that extends beyond, you're not allowed to open until Christmas Day, then why aren't the closures after the 27th of September, when the period of insurance has ended, a consequence of the fact that you were closed on the 1st of September?
Well, the distinction is that we accept that on your Lordship's example, that there would be cover for the 27 days or so until the 28th of September when the policy comes to an end for the closure. There would be consequential cover for that closure within the policy period, which might include restart costs. They might be substantial, they may not be substantial. To the extent that there is subsequent closure after the 28th, that is something that simply falls outside the scope of the policy. Because it's simply covering, because it's expressly covering, we say, the enforced closure or the prevention of access within the policy period. That's the reference to during. It's not talking about initiating event, it's defining the scope. And so to that extent, that simply being closed after the 28th of September is not covered at all. That's the distinction we say.
You,
That's
you
the
may
result.
be right or you may be wrong, but it leaves the insured with quite an exposure, doesn't it? Because the insured's never going to get alternative insurance cover.
Well, Lord, I think that's the main point the judge made. I think if I may say so, that the judge said, I've not manipulated I can do this without manipulating the language. Your Lordship has my submissions as to why we say, no, that's not right. If you read it fairly and naturally, it is focused on prevention of access within the period, we say. And we say that that is supported by the other terms within clause 2.3 itself. One then gets to the question of, well, do the consequences of that interpretation drive you to another result? And my first submission on that is to say that we say that there is no relevant ambiguity in this case, and there's no contextual support to suggest moving from the natural meaning, and indeed we say the opposite is used in the policy when it intends to, it specifically refers to commencing. So that's an unpromising start for using commercial consequences. And if your Lordships will bear with me, I will take your Lordships to one construction authority. And it's because it does encapsulate the point that we make very well. It's Arnold and Britton dealing with commercial common sense. It's an authorities bundle authority bundle 1, tab 3, paragraph 17. And I'm conscious your Lordships will be familiar with this passage, but since it is directly on point, we say, I do take your Lordships to it.
It's always cited by those who wish to insist on strict and uncommercial construction.
Well, I'll come back to whether it actually how uncommercial it is. I certainly accept it has what may be unattractive consequences for the insured. I accept that, and the judge's point on that is right. I accept it leads to less cover for the insured. And my Lord, it's paragraph 17 onwards. On Lord Neuberger. First, the reliance placed in some cases on commercial common sense.
Well, should we read that?
Yes, if your Lordship, and I'll just highlight thereafter the key points I take from it.
Where do you want us to read?
It's paragraph 17 to 20.
Yeah, I mean, it's cited on not quite a daily basis, but certainly in most cases.
Yes, no, I'm conscious it is, but we'd say it's particularly apposite in this case.
Anyway. Yeah, I mean, it's 20 really, isn't it? What matters is what they've actually agreed on.
Well, Lord, it's also relevant, paragraph 18, I was going to highlight, which is how carefully a policy or a contract has been drafted. And 19, that it shouldn't be retrospective.
That might be thought to be quite dangerous ground in the case of an insurance policy.
Well, if I first go on the point of...
This one's better than some, but all insurance policies tend to suffer from an element of confusion.
Yes, but one can always find confusion if one searches for it. But I think what
I'm only really teasing.
Well, what I was going to suggest is in this case, we are at the more extreme end of a carefully drafted and thought out policy 120 definitions, 40 pages of policy, countless pages of definition. It doesn't mean it's perfect in every sense, but it does mean, in terms of the approach to law, as Lord Newey says, one perhaps has to be more careful about assuming that although the word may have be regarded as having uncommercial consequences, that isn't what parties intended. This is, after all, a policy that's used by multiple insurers. Now, in this case, what we're contending for is not at some sort of a construction that removes an element of core cover. What it simply means is that in some situations, there may not be full coverage for the full consequences of what occurs. Again, one might say, well, it's not surprising as a starting point that the policy isn't seeking to cover closure which is outside the policy. It can do, I'll come back to it, but there's nothing inherently surprising in a policy for a certain policy year to say, well, I'm covering you for the closure within this year. Now, a bit like claims policies, etc., there may be good reason why one needs to provide a bit more protection, and why one might want to, for an insurer, to provide a bit more protection. But there's nothing unusual or absurd in limiting cover in that way. And indeed, there may also be cover ongoing under other clauses. So, for example, in this case, there may not be cover under a disease clause, even if there isn't cover under the prevention of access and enforced closure clauses. And equally, there is nothing in itself unusual that you may find yourself in a position whereby, as a result of new risks developing, that you can't renew on exactly the same terms, or you've got to pay more premium. So the mere fact that there might be a gap of cover, or you'd have to pay a lot to ensure full cover, isn't itself an answer. That is an inevitable consequence. Now, it's one that could be drafted out, and one might say, well, a good broker would try and draft out those risks. But it's nothing absurd.
Both the other business interruption covers, property damage and act of UK terrorism, contain the words during the period of insurance, but make it pretty clear that you get cover for all the consequences of an event which happens on the last day of the period of insurance. So if there's a fire or a terrorist attack which closes the property for a year, you get the full business interruption loss. Now, it would be surprising, wouldn't it, if business interruption specified causes was entirely different?
Well, but we say it's because the peril's different. I mean, the peril in the case of a burnt down building is you are getting all the consequences of the burnt down building within the period of cover. I mean, perhaps the more apposite example would be if you had some form of continuing loss over the period, over the two beginning and end, then you would have effectively the same argument. Does the fact that the damage has started within one period mean that you're covered in the second period? But if you have a fire case, house burnt down.
But nevertheless, it is implicit in your submission that the same words during the period of insurance are doing an entirely different job in 2.3 from what they are in 2.1 and 2.2.
No, because we're saying in those other scenarios, the entire insured peril has occurred within the period of insurance. Whereas the difficulty with this case, the assumption in this case is that there is a 3-week closure and only half of it is within the period of insurance. And my submission is simply, this policy covers the bit that's within the period of insurance and the consequences of that, just like if the fire was in that period, it would cover all the consequences of the restaurant or hotel burning down. What it wouldn't cover is a fire after the period of insurance.
Can I, as the non-specialist, just look at the wording? So if we take 2.1, damage during the period of insurance as a result of an insured event which causes interruption or interference. Is the bit about causing interruption or interference part of the insured event?
Sorry, Lord, which clause?
Sorry, 2.1, but it's the same with 2.2, I think.
Sorry, Lord, I'll come back to the... So, Lord, every element of the peril, I think that the Supreme Court confirmed that the first part, in the event of interruption of the insurer's business, is not to be regarded as part of the peril. So I think the Divisional Court had held that it was part of the composite peril, and the Supreme Court held it wasn't. But every other element is part of the composite peril. And of course, the key element, if one goes back to page 30 on the prevention of access, because it's perhaps the easiest clause to see it, is how it's qualified. It's the fact that what has to happen within during the period of assurance is the prevention or hindrance of the use to the insurer's locations. It's not the reference, or not specifically the reference, or only the references to the actions to the police or law enforcement agencies, because that's what the judge has done. The judge has done and said, well, you've identified an initiating event. There's actions of police or government in terms of closing down the property. That's enough. And thereafter, you get the consequences of that. But that we say is ignoring the rest of the composite peril, which includes during the period of insurance, which is defined, prevention of access, which is defined to be limited to the during the period of insurance. And so you can only draw the consequences and the losses that arise from that defined covered event.
Well, one minor thing that I find slightly puzzling, it's probably just odd drafting. If you take definition 87, prevention of access non-damage, that sets out various things, and it says which prevents or hinders the use of or access to insured locations during the period of insurance. So it's tied to the period of insurance then. Now we then put that back into 2.312, and we get prevention of access non-damage during the period of insurance.
Yes, well, there's a double during the period of insurance.
Yes, I see.
I mean, obviously, under 8.12 notifiable diseases, the definition doesn't itself include a during the period of insurance element.
I mean, it might be thought to help you that you get the double period of insurance.
Well, I don't take, because obviously I'm conscious that the enforced disclosure doesn't, but it is underlining that certainly the prevention of access clause, that the defined element of what is the peril uses the word during the period of insurance. As I said, I don't want to try and make this sound too complicated, because it is a very narrow point. And in my submission, the judge, I can understand where the judge's reasoning of trying to say, well, wouldn't it make more sense to? We just say it doesn't. I mean, as I said, it could have provided differently. I mean, there are advantages to this aspect. I would say it provides a clearer line. It perhaps is unrealistic on these types of policies, because these are, on the whole, quite big policies. Perhaps one shouldn't necessarily assume that it wouldn't be covered in year 2. These are big policies with typically big insurers and big insurers. So perhaps one should be careful about making assumptions what would in fact happen. But the converse of that is, this is a policy where Marsh is the broker, and it's a standard form wording, and the most obvious way is to apply it as it is written. Now, my learned friend referred to, I think the Chancellor referred to the indemnity period definition, which is at page 26 of the bundle.
Yeah.
We say that simply doesn't assist at all, because what the indemnity period is what it's confusing is the aspect of the extent of the interruption or interference of the business for which one is liable, which can indeed continue until the end of the maximum indemnity period, and what is actually insured under the enforced closure and prevention of access clauses. And the indemnity period is not trying to answer the question of what is insured, it's telling you what consequences are covered and the extent of the consequences. So it doesn't answer, it doesn't tell you what the scope of coverage is in the first place. It's providing simply a long stop for the consequences which are in fact covered. But if the clause tells you you're not covering prevention of access outside the period of insurance, that's that. It doesn't follow on from that, because the clause has told you it's not covered. Insofar as it is available, then it allows you to have coverage up until the end of the maximum indemnity period. So we do say, I mean, it is a short point of construction. We certainly recognise it could have been drafted differently. As I said, it's a standard wording on the Marshal Residence wording. We invite your lordships to follow the natural meaning, which is supported by the rest of the draft 2.3. And to conclude that it is limited in scope. Lord, those are my submissions in terms of the opening, unless there's anything I can assist with at this stage.
Thank you very much, Mr. Thomas.
My lords, as Mr. Doherty indicated, I'm going to first respond to Allianz's two grounds of appeal, and then I'll move on to deal with various Eateries' own appeal. I'll take the prevention of access enforced closure ground first, partly because we've just dealt with it, but also because it is a covered event or period of indemnity issue, so logically precedes the aggregation issue, which is Allianz's other appeal ground. We agree it's a pure point of construction. You've been taken to the relevant part of the judgment which deals with this issue, which is paragraph 67 to 69 of the VE judgment. I don't think you've been taken to the relevant declaration, and it might be worth just looking at that for completeness. It's at core bundle tab 14, page 234, and it's declaration 7.1.
Hang on a sec. Tab 14.
Tab 14. You'll see that provides this cover for interruption or interference resulting from a closure or a prevention hindrance of access stroke use initiated during the period of insurance for as long as the closure or prevention hindrance remains in substance the same, and in any event for no longer than the maximum indemnity period. Now, our response to this appeal ground is at section C of our respondent's skeleton at paragraphs 41 to 52, which is at tab 8 of that same bundle, the core bundle, pages 88 to 90.1. And we say that the judge was right in his finding that the words during the period of insurance refer to the initiation of the closure, stroke, prevention or hindrance, and do not mean that there is no cover for any period of enforced closure or prevention of access after the end of the period of insurance, even though that closure or prevention has begun during the period of insurance. And we say that both for the reasons he gave, and insofar as it's not already implicitly captured by the judge's analysis, there's one further reason set out in our respondent's notice, which concerns the definition of the indemnity period. I will go on and deal with what we say is a new case that's now being put, which is that there would be cover for the consequences of the period of closure or prevention of access that occurs during the period of insurance. But let me deal with what I understood to be the case, and we say the judge understood to be the case that was being advanced by Allianz first. We say that the judge rightly read the words during the period of insurance in the context of the policy as a whole. And if we look back at the policy in supplemental bundle tab 1, volume 1, tab 1, page 7, we can see that what is insured is in the event of interruption or interference to the insured's business as a result of, and then we have our list including notifiable diseases and other incidents during the period of insurance, and then prevention of access, non-damage during the period of insurance where such interruption or interference is for more than 8 consecutive hours. Within the territorial limits, the insurer agrees to pay the insured the resulting business interruption loss. So we say that that is consistent with the interpretation that the insurer has agreed to pay the business interruption loss, which is proximately caused by the insured peril, subject, of course, to the other terms of the policy, including the maximum indemnity period. And we say there are no words in the insuring clause itself which would support Allianz's construction. We would say, on the other hand, what Allianz is seeking to do is rewrite clause 2.3 as though it said the insurer agrees to pay the resulting business interruption loss, but only business interruption loss resulting during the period of insurance. And we say the absence of that sort of limitation in the clause itself is a strong indicator that that is not the objectively reasonable interpretation of the policy. If we look at the definition of business interruption loss, which is at definition 9, it's at page 23 of the policy, same bundle, supplemental bundle 1, page 23, we can see that at the top on the left-hand side, business interruption loss means the reduction in turnover, increased cost of working and or research and development expenditure. And definition 9 is incorporating other definitions, as we can see from the bold. So reduction in turnover is itself defined at definition 93, which is on page 32. And we can see there that it means the amount by which turnover during the indemnity period falls short of the standard turnover, less any costs normally payable which cease or are reduced during the indemnity period as a consequence of the covered event. And so there's reference to the indemnity period there. So in assessing such loss as is recoverable in relation to the perils under clause 2.3, the policy is expressly envisaging that a reduction in turnover after the end of the period of insurance is relevant. And we say that would make little sense if the only recoverable losses were those resulting from reduction in turnover during the period of insurance. The definition of increased cost of working also refers to the indemnity period. We see that at definition 41 on page 26. Which again refers to the indemnity period twice. And then we have the definition of the indemnity period at 42, and that's quoted in the judgment at paragraph 38. And that is, indemnity period means the period of time during which interruption or interference to the insurance business occurs as a consequence of the covered event, beginning with the occurrence of the covered event and ending not later than the end of the maximum indemnity period thereafter. So we say that that definition presupposes covered events occurring during the period of insurance, but continuing thereafter, subject to causation being established, up to the end of the maximum indemnity period, which, as we've already seen from the schedule, was here 12 months for certain locations and 24 months for other locations. And we say that Allianz's construction is inconsistent with the natural and ordinary meaning of that definition of the indemnity period. So what the policy is doing is drawing a distinction on the one hand between covered events and on the other hand between the recoverable business interruption loss resulting from those events. And the indemnity period makes that plain because it's expressly envisaging that there can be business interruption loss beyond the period of insurance. And we say Allianz's approach collapses that distinction because it treats the policy as if it required not only the covered event to have occurred during the period of insurance, but also the resulting business interruption loss. Now, to deal with the argument that's just been put, which is, no, you're mistaken about that, because what we're saying is that any post-period of insurance loss that is attributable to that period of closure or prevention that occurred before the end of the period of insurance, that would still be covered. Now, that would seem to be, we would say, inconsistent with the way that the case is put in Allianz's skeleton. We go in the core bundle to tab 7, page 63. We see there at paragraph 52, that what was being said is, in considering commercial common sense, the judge failed to take account of the commercial value of a readily identifiable cutoff to cover.
Sorry, which paragraph?
52, page 63.
Yeah.
tab 7. And what was being said is
gotcha.
that there was a cut-off to cover, ending with the period of insurance. And that also seems to be, as the judge understood Allianz to be submitting at trial, because if we look at the judgment, which is at tab 15 of the core bundle, page 257, the whole of the discussion about the uncommercial and unintended consequences is all premised on there being no cover after the end of the period of insurance. I'll come back to that in a moment, but it was not what we understood Allianz to be submitting at trial. It's not what the judge understood Allianz to be submitting at trial, and it's not how the case appeared to be put in the skeleton.
And sorry, just on this point, how the judge saw it, which bit of the judgment do I look to see that?
Well, he's talking about how the only cover on the, for example, the bottom of page 257, para 69,
Yes.
if an insured location were the subject of enforced closure on the last day of the period of insurance and remained closed for a week, the only cover would be for the consequence of the first day of closure. Whilst
Could that not be consistent with the case now being put where Mr. Doherty says, well, yes, you're covered for the first day of the consequences of that?
as I said, that was not how it was put, and then we would say that was how the judge understood it. The cover simply cut off. You had this bright line. So on the 28th of September, that was it.
Speaking for myself, Mr. Milkey, I'm not sure. I mean, I follow the point you're making, but I'm not sure it necessarily helps you, because in one sense, the way in which it's now put actually is more helpful to you. Because if I go, for example, because you showed us the definition reduction in turnover,
Yes.
on the insurer's case that's now put forward, one gets into all sorts of a tangle about working out how the amount by which the turnover during the indemnity period falls short of the standard turnover if all you've got cover for, in my example, is the 27 days, as opposed to for the entire indemnity period.
Yes,
It just doesn't
absolutely,
make
precisely.
sense.
I was going to go on and make that point, and it was one that the Supreme Court was grappling with in the FCA test case in relation to disentangling the causative effects of cases of disease that were insured versus uninsured. And we can go to it if necessary, but paragraph 201 of the FCA test case makes clear that it becomes practically unworkable to try to disentangle here the causative effects of a period of closure or prevention during the period of insurance, but versus the continued period
The judge's point is
outside.
a very simple one, that provided you've got prevention of access during the period of insurance, even if the prevention of access continues thereafter, you've got cover
And as long as it doesn't,
for the rest of the indemnity period.
correct, subject to causation.
Subject to causation.
And as long as it doesn't materially change.
Yeah, of
If
course.
there was something
Well,
material, that would then bring it
If you
to
had
an
an
end.
interruption, obviously if the prevention, if you look at it in terms of what really happened on the ground, if after whichever date it was in July 2020, there's no longer a prevention of access. I mean, if we move that forward, if this had all happened in September and November, if by the beginning of November the prevention of access comes to an end, then that's it. And the fact that there's then a subsequent prevention of access in December or January doesn't make
is
any
not
difference,
covered.
because there wasn't any cover.
And-
The
and-
insurance had come to an end.
There is an enforced closure in September because there was early closing where
Yeah, I know.
hospitality venues had to close by 10 p.m. So there was some loss arising from that. But that goes over the end of the period of insurance of I think it started on the 24th of September, it continues through. And then it gets superseded by the second lockdown on the 5th of November. So it does arise, and we say the judge was absolutely right. As long as it continues materially unchanged, then the losses are covered arising from the whole of that period of closure or prevention. And it's simply not going to be practically workable to try to take two different periods and work out the causative effects. It comes back to the Marrickville point about being able to quickly calculate losses and for this to be a workable policy from the policyholder's point of view. But we would say it's also supported by the nature of the covered events that the judge was considering, and we can see from paragraph 67 of the judgment that he has well in mind that in relation to enforced closure, the nature of the peril is an enforced closure during the period of insurance. In relation to prevention of access, Again, it's actions or advice that have the effect of preventing or hindering access or use of the insured locations. Something that will immediately give rise to loss. I have in mind my Lord Justice Newey's point about food safety investigations, where you may have a commencement of an investigation, but it doesn't necessarily immediately give rise to loss, which inevitably closure or prevention or hindrance is going to do. And we say that Allianz's construction is trying to merge the peril with the extent of the business interruption loss that's resulting from that peril, and the judge was right to distinguish the two. Just to respond to my Lord Justice Mayall's query about...
I think you've got them the wrong way round.
You've got them the wrong way round.
I'm so sorry.
That's Lord Justice Mayall, that's Lord Justice Newey.
I'm so sorry. But just to respond to my Lord Justice Newey's query about interruption or interference and whether that is part of the peril, just to give you the reference to that, it's in Authorities Bundle 1, the FCA test case. It was paragraph 215 on page 374.
Two on five.
215. And rather than read it to you, I'll just invite you to have a look at that. But that's where the Supreme Court accepted Mr. Salcedo's submission in relation to interruption and interference being the type of loss rather than part of peril. And just to conclude on this point, and going back to paragraph 69 of the judgment, we said the judge was also right to consider it would lead to uncommercial consequences. He refers to if the closure was for a week, starting on the last day, you'd only have cover for the first day of closure, and then the insurers for the following year would exclude cover for an already subsisting covered event. Absolutely makes sense. He talks about the requirement for 8 hours of interference and interruption in the prevention of access policy. There'd be no cover if the prevention of access started within 8 hours of the policy period end. He contrasts it with the fire example, where you'd have the entirety of that closure covered. But on Allianz's case, it's different if it's enforced closure for health reasons, which is paradoxical. We say there's no error here. This was an application of the iterative approach to construction, which is consistent with the approach of the Supreme Court in the test case. An example of, we don't need to go to it, but is paragraph 227, where the Supreme Court was rejecting Hiscox's interpretation in that case of a counterfactual, where it was being posited that COVID occurred and all of the government restrictions were the same, but you treated the policyholder as if uniquely they'd remained open despite all of this, and you only focused on the loss, therefore, that had been suffered. And they said no reasonable policyholder would have understood the insurance cover that they were getting to be insurance against such a narrow and fanciful risk, and it would make it a wholly uncommercial form of insurance. We cannot imagine any insurer would see any sense in offering, or anyone running a business would see any sense in buying. And we say that that is the same approach the judge took here. He was right to look at the commerciality, and even if some business interruption loss after the period of insurance is covered because it's a consequence of the closure during the period of insurance, it's still going to mean that it's the rest of the business interruption loss from the rest of the closure is uninsurable. Because who is going to insure it? It's already subsisting. So we think, for the reasons the judge gave, those points remain good and address even the revised case, which is that some consequences are covered.
Just for completeness, before
Yes.
you move on, picking up the point I was worrying about a moment ago.
Yeah.
If you go to clause 2.312, where we get prevention of access non-damage during the period of insurance, and as Mr. Doherty was saying, there's a double during the period of insurance. on your construction, are the words during the period of insurance redundant?
There has to be a prevention of access during the period of insurance for there to be
That's in the
cover.
definition.
But that's it seems to be duplication, but
Yes.
we wouldn't submit that the fact it's there twice has any relevance. Clearly, the closure has to start or the prevention has to start during the period of insurance. But if it continues after the policy period end, that all of the consequences are recoverable subject to causation. So that was all I was proposing to say about the ground two.
Yeah.
And if I turn now to the aggregation ground, this is that the judge was wrong to find that all of the claimant's COVID-19 related business interruption loss insured pursuant to the policy does not aggregate as an SBIL. And the appeal ground relates to what has been termed by Allianz its Wuhan transmission or outbreak arguments and its initial introduction to England or the UK arguments. And there are 7 of them. They're set out at paragraph 6 of our responsive skeleton. That's at core bundle 8, page 67. So we have candidate 5, first human-to-human transmission of SARS-CoV-2 in Wuhan. Second, the first relevant one, which is the one that went on to generate sustained community transmission, it's alleged. Candidate 7, the initial outbreak in Wuhan in November/December 2019. And then we have first transmission in England or the UK, initial introduction of COVID within England and within the UK. And the grounds of appeal are that the judge erred in not finding that the first human-to-human transmission or the first relevant human-to-human transmission was a single occurrence within the meaning of the SBIL definition, to find that all of the Wuhan arguments were too remote to be regarded as relevant consequences, notwithstanding they were causally connected. Sufficiently causally connected with these losses to satisfy the causal requirement in the SBIL definition, and then to find that the initial introduction to the UK or the first transmissions within the UK, human to human, were single occurrences rather than finding that they were not connected and were too remote. Now we've addressed this ground in our responsive skeleton at section B, paragraphs 3 onwards. And perhaps I can ask you to go to that because I'm going to try and deal with the submissions by reference to the skeleton. So it's tab 8, page 66 onwards. And V's position is that, again, that the judge was right to find that none of the 7 candidates were relevant aggregating occurrences for the reasons he gave. But also for the additional reasons in respect of candidates 5 to 7 that we've set out in the respondent's notice. And they're complementary to the reasons given by the judge. They don't arise if your lordships hold that the judge was right to reject those candidates as relevant aggregating occurrences on the basis that they were too remote. But I'll come to those in due course. We say at paragraph 9 on page 68, we start with 3 general points by way of overview. And the first point is what we say is in reality and in the context of this case, as opposed to other potential aggregation cases, this is a challenge to an evaluative decision. We say it is an evaluation of the facts by reference to a legal standard, rather than a challenge to the judge's analysis of the principles of aggregation or his construction of the aggregation wording per se. And we've already looked at it, but it is worth, I think, going back to have a look at it again. Scott and Copenhagen Re, which is in volume 2 of the Authorities Bundle, tab 23, pages 750 to 751. paragraph 81, and I want to also just go to 82. There was a submission that the test of the unities was inappropriate, where one event leads to both immediate total losses and the total and to other total losses more distant in time. And he said, I disagree. The submission highlights the issue in this case and also begs the question, are the losses to be aggregated as all arising from one event? That question can only be answered by finding and considering all the relevant facts carefully and then conducting an exercise of judgment. That exercise can be assisted by considering those facts not only globally and intuitively and by reference to the purpose of the clause, but also more analytically, or rather by reference to the various constituent elements of what makes up one single unifying event. It remains an exercise of judgment, not a reformulation of the clause to be construed and applied. And then in paragraph 82, it was held that there was nothing wrong with the exercise conducted by the judge, which was focusing on unity of time being lacking, and Dawson's Field unity of time was critical. In the present case, there was unity of place only, there was no unity of time. So looking at the detailed components of the test and upholding the judge's approach to it. And we say that it's a different context from the examples given in the well-known Generali and Arab Insurance Bank case, which I won't, Arab Insurance Group case, which I won't go to because I know the court is very familiar with it, but that was looking at whether a contract of service existed, taking account of the facts, or the assessment of whether a trademark should or should not be registered because the goods were identical to or similar with those protected by an earlier trademark. We say that's not dissimilar to the situation here, where you have to take all of the facts into account to decide, was there a single unifying event around which the losses aggregate? And the judge was considering a range of potential aggregating factors here, not just one, you know, is there aggregation around this or not? It was a whole range. He had to try and assess how they fit together with one another, their causal connection with one another and with the loss, as well as the overall exercise of judgment. And we would say that is an evaluative decision. There's no real dispute here about the meaning of occurrence or in connection with. The challenge being made is essentially about the application of the clause to the complex facts. And in terms of the fact that the judge himself gave permission to appeal, that doesn't affect whether this is an evaluative decision. It's simply saying that it was arguable. It'll be a matter for this court as to what it is, but clearly in circumstances where it is an evaluative decision, an exercise of appellate restraint is usually called for when determining the appeal. And the situation here was the judge heard limited oral evidence in the end, unlike in Stonegate where the experts did all give evidence, because Allianz, having had limited examination in chief, then decided not to rely on its own expert, Professor Hiscox, but rather to agree Professor Pybus's evidence. But there was a great deal of written expert evidence before the court and a lot of supporting material, all of the papers that went behind those expert reports. And we would say in the absence of a clear identifiable error of law or error of principle in the judge's approach, that appellate restraint would be appropriate in this context because it's impossible to replicate that exercise on appeal. The second point we make is at paragraph 11 of our skeleton, page 69, which is a short point, and that is irrespective of whether or not these matters relied on were occurrences, Allianz still has to show they're not too remote from the loss. And that was the judge's key finding in respect of all of them. And otherwise the appeal ground fails. And then our
just on occurrences.
Yes, of course.
Can you explain the apparent tension between declaration, whatever it was, 7.1 I think, and paragraph 92 of the judgment?
7.1 is enforced closure.
Oh, is it? I got the wrong one. It's
Is
11.
it 11?
So it's under question 7, but Declaration 11, apparently saying no single occurrence.
Yes, I'm going to be dealing with that in terms of.
All right, well, if you're going to deal with that later.
I need to explain what was argued in the different cases, because it's rather a product of that as to why there wasn't a finding in the end, which I'm assuming is what you're asking me about, as to why there was no single occurrence.
Well, in the body of the judgment, paragraph 92, he appears to say that he accepts there was a single occurrence,
Yes.
albeit not as precisely defined
Yes,
in the box.
that's
of
because
candidates.
it was animal to human spillovers,
Yes,
whereas Allianz's case was actually for human to human transmission, or an initial outbreak, which was understood by the judge and indeed by us to follow that initial.
So what's the position? Although they had 17 shots at identifying the single occurrence, they failed to hit the one bullseye which the judge accepted in the other cases, and therefore they lose?
That was not the case that was being advanced. It's now said that that's what we meant by initial outbreak, but that's not the case that was being advanced in Allianz. I'm not suggesting that the judge, having found that that's a single occurrence in one case, wouldn't, had it been argued, have found the same in this. It doesn't help them because there's still issues on causation and remoteness.
Of course, but at any rate, that first step.
Yes, but it was a different argument, and that's why it's reflected in the declaration as not having been a single occurrence. But I'm going to deal with that and show you how the case was put.
I probably shouldn't ask you to deal with it now, but just so I'm clear, where the judge says in paragraph 92 that the initial human infections could be described as a single occurrence, what do you take him to be referring to?
The 2 to 15
Spillovers.
from animals to humans, which he said occurred in Huanan market, probably occurred in Huanan market within a relatively short space of time.
Yes, I see. So you say that wasn't one of the candidates?
That was not one of Allianz's candidates. All of Allianz's candidates were human to human, we say.
Yes, I see.
As I said, they're now saying that's not what they meant, but that was not how the judge understood it. It was not how we understood it. It came up at the consequentials hearing, and I explained that was my understanding of what had been argued, and there was no response to that. And the declarations were then drafted in light of the judgment and agreed. But it was a different case. The initial human infections were animal to human, not human to human, and certainly not anything thereafter.
What do you say?
Sorry.
I said, but what do you say we do now? Suppose we're with you on causation and remoteness. Well, it doesn't matter. But suppose Mr. Doherty has persuaded us on causation and remoteness. Do they lose because they haven't pleaded that particular occurrence?
Well, my submission would be they don't win on causation and remoteness. I'll come on to that. But if you were to conclude otherwise and were satisfied that they had pleaded it, as I said, I think I can show you clearly it wasn't.
So your position is because they didn't plead that one.
That was not the case we were facing.
They lose.
Yes, that was not the case we faced at trial, and it's not the case the judge understood. So his reference to that is really a product from the other importation from the other judgment with a different case.
And just showing again what I haven't read, I've seen these various candidates set out in the skeleton arguments and the judgment, but they must come from something. Is that from the defence or?
Yes, that's from the defence. Let me
Yes.
take you to that. So, page 354 in the core bundle, it's tab 20. It's tab 21.
And so it's paragraph 37 where we get the candidates, is it?
Correct.
Yes.
So we start with virology ones. We have mutations, single infections. We then come on to 37.1, the first relevant to bring about sustained community transmission, human to human transmission of SARS-CoV-2, COVID-19, believed to have been in or around Wuhan in around November 2019. And then that's followed by 37.2a, and I would say the place in the list is significant, the initial outbreak of COVID in Wuhan in or around November, December 2019.
So assuming they were always thinking that there was an intermediate animal or whatever, they've missed the link from the animal to the human.
Exactly. Save insofar as it's covered in single host, the virology issues which are not being pursued now. But it was always
and that's
about
the
human.
infection of the host, not the passing on from the host to somebody
Yes.
else, is it, or to a human.
There was no case that was animal to human transmission in the Allianz list of 18 aggregating events.
It's the case of the missing link.
And the judge summarises the list of aggregating features in his judgment at para 90, page 262. You'll see that there are 18 arguments. So the virology ones, mutation, most recent common ancestor, infection with the genomic sequence, equal to lineage B and then B1. All of those have gone, they're not appealed. So the appeal relates to arguments 5 to 7 and 8 to 11, which are human-to-human transmission, initial outbreak in Wuhan, first transmission in England, initial introduction in England or the UK. So what we would say is Allianz advanced no less than 18 arguments, starting with Wuhan, continuing through to government action in the UK, which was its 18th on the 16th of March. The judge accepted only argument 18, the one that was the latest in time and closest in geographical terms, which was the UK government action in response to COVID in the UK from March 2020 onwards. Allianz has abandoned 10 of its other 17 candidates, but it does seek to go back now to the opposite end of the spectrum, temporally and geographically, to provide its so-called meaningful explanation for these business interruption losses. In the context of Allianz's initial introduction to the UK or England arguments, the court may wish to note, and we can see this in the supplemental bundle in the Stonegate judgment, and I'd ask you to have that out because I do want to go to that in the course of my submissions, but at paragraph 117 of the Stonegate judgment, which is in supplementary bundle volume 2, tab 18, page 518.
Sorry, supplementary bundle 2.
Tab 18, page 518, it's the Stonegate judgment.
Oh, right, okay, Stonegate. Which page? Which paragraph?
518, paragraph 117. You'll see there were 19 cases pleaded by Stonegate insurers. One of those cases, what was called option 6, aggregation by reference to the initial outbreak or arrival of SARS-CoV-2 in the UK by the 31st of January 2020, was expressly abandoned. So the UK arrival candidate or candidates was abandoned by the Stonegate insurers in that case. And we say that's not at all surprising because the expert evidence was that there was no single first human-to-human transmission or initial introduction in the UK. Rather, the evidence was that there were 1,179 independent, separate introductions. So the case that my lord referred to earlier of, the Chinese woman whose son was in York and so on, that was not a point source for this outbreak.
No, well, that's the whole point, isn't it?
Yeah.
That there were any, and there might have been even more than 1,000.
There may well be.
If it may be by the end of the inquiry, it'll be tens of thousands or hundreds of thousands.
Well, Professor Pybus had been involved in that leading study, which had assessed the genetically distinct introductions that had come in. But I'll come back to the evidence in a moment. In terms of the legal principles, I don't know if this would be a good time before I move on to this section to have.
Should we take a break for 5 minutes?
All rise. Yeah, I like IT. 4 eyes.
I was about to turn to the judge's summary of the legal principles on aggregation. He does this primarily in the Stonegate case, so if I can go back to the Stonegate judgment again, SB Volume 2, Tab 18, pages 510 to 512, it's paragraph 78 to 90.
Yeah.
And the summary that's set out there, it doesn't appear that Allianz is taking issue with any of that as a misdirection of law. I wanted to just draw attention to paras 88 and 89 in particular, which relate to remoteness, noting there's a distinct requirement of lack of remoteness between the aggregating event and the losses, and that in Scott and Copenhagen Lord Justice Ricks referred to it as a tool to limit the otherwise infinite reach of the workings of causation and a legal tool to separate out relevant from irrelevant causes. As a result of its use, the court will look for a nearer and more relevant cause than a more distant one. And then at 90, the ultimate question is referred to there, the issue of whether losses can properly be aggregated, and if so, around what event or cause, is to be answered as an exercise of judgment based on all the relevant facts and the purpose of the clause. And we've already looked at para 81 of Scott and Copenhagen. Just dealing with the causative link, he deals with that at 87, saying typically aggregation clauses require a significant causal link. And with a reference then to Scott and Copenhagen again and what was said there. But in dealing with the clause, the causative clause in this aggregation clause, this is addressed at paragraphs 113 to 116. And we can see there that the judge accepted that the words "in connection with" as part of that clause were wide linking words. At the bottom of 113 would denote only a relatively loose link was required, and thus a wide range of losses might potentially fall to be aggregated as being at least connected with an occurrence. And he, at 116, he then goes on to say, but it must still be causal, because the insurers in, I think, all cases were arguing it didn't have to be a causal link. And he rejected that and said it did have to be causal. At 115, 4 lines down, I accept that the parties must have contemplated that the occurrence should be a meaningful explanation of the losses to be aggregated, can only be meaningful if it had some causal relationship to them. And then at 116, I accept nevertheless what's required is a relatively weak causal linkage, and it did not require to be approximate sole or main cause, could embrace indirect causation. So he made his findings about this clause. It wasn't transporting Scott and Copenhagen Re, which was arising from, or arising out of. In terms of Allianz's reliance on the Silversea case and the, quote, single defining event that Mr. Justice Tomlinson, as he then was, referred to in that context, that was an obiter and very brief discussion of aggregation. And we would say that the reference there in slightly different terms to a single defining event being the 9/11 attacks doesn't establish a different test for single occurrence, as it's already been interpreted in all the aggregation authorities that we've seen, and it doesn't establish any wider proposition. It was the way that the judge in that case addressed what he saw as the impact of the 9/11 attacks. I want to address this suggestion that remoteness should have been of more limited or lesser importance than the judge attached to it. We say that's incorrect. The judge recognized it was a distinct requirement, and that isn't disputed at paragraph 88 of Stonegate, and one which is a tool that will limit the otherwise infinite reach of the workings of causation and separate out relevant from irrelevant causes. And we would say it's a critical component of the overall legal test for aggregation. Spire and RSA doesn't assist Allianz. It's relied on them. We've looked at it. I wasn't going to go back to it. But there, Lady Justice Andrews was agreeing that there must be some limit to the degree of remoteness that is acceptable. And when you're searching for the unifying factor, you don't go so far back in the causal chain that you're in the realm of remote or coincidental causes, which provide no meaningful explanation for what has happened. Having looked, we think that is the origin of the meaningful explanation description. We can't find any other case referring to it other than Stonegate, which repeats it. Mr. Justice Butcher in these cases adopts it. And what she was doing there was essentially applying that remoteness test then to the conduct of the surgeon. And seeing whether that conduct provided a meaningful explanation for the underlying personal injury claims.
What do you say about that test in this case? Is that a useful concept for ascertaining what is too remote and what isn't?
It's rather a gloss on what seems to be a well-established, you need your single occurrence here in the meaning of the clause, your causative link, which the judge has said is relatively weak, your remoteness test to then take potentially causative events, but to limit the reach of those, and then to make the overall judgment. So it's a way of looking at it and trying to reach the same conclusion, but it shouldn't be elevated to something completely different in and of itself.
Is it the same? I mean, it's not the same test as proximate cause, but is it really the same concept, if you like, as effective cause? I mean, in other contexts, in other causation contexts, one's looking for the effective cause.
It's
I mean,
clearly,
in a sense, that's the exercise here, isn't it? That what the judge is saying is, well, these earlier matters, even if they were a single occurrence, are just too far in the past, or or insufficiently causal
yes.
to therefore be remote, and they are not the effective cause. And the effective cause is the government diktat, or whatever one describes it as, on the 16th of March.
I'd hesitate to adopt the language of effective cause.
Well, I understand that, but I'm just trying to understand
it's clearly not proximate cause.
the exercise seems to me to be not dissimilar one.
But
I think Mr. Doherty used the words most relevant.
Yes.
yes.
Would that work?
There is talk about the nearer and most relevant. We have an issue about whether nearer is, and we don't mean it to mean just nearer in time. Most relevant or more relevant, yes, would probably be a less controversial way of doing it. But
I don't think the judge was using nearer necessarily in a temporal sense. He was simply looking to see, well, what's the real cause, the most relevant, as my lord says.
You know, it's back to this question: are the losses to be aggregated as all arising from one event? And the case law is grappling with this by looking at significant causal connection. I think significant may be an appropriate word for it rather than effective, or it's certainly not proximate, and one does have to take account of the causative language in this clause, and I'm not suggesting otherwise.
Sure.
But remoteness is a distinct component of the exercise of looking at it analytically and then performing the exercise of judgment of having considered all the relevant facts, having considered it analytically. Is there a single unifying event, in the words of Ricks?
Well, it's the infinite regression point, isn't it, that Justice Ricks refers to?
Yes. There must be
the same
a
point as the Ice Age point in Cornwall and Sharp.
yes. I think we would agree with that. Simmons and Gamel, which is also relied on, we say is a very different factual context. The issue of remoteness wasn't given specific consideration there because it was obvious that despite the distance in time, there wasn't any nearer causal event that provided a more meaningful explanation for the loss than the attacks which had led to the destruction of the Twin Towers. So it's very much fact specific. There is an ultimate question. we would say if having looked at is there an occurrence, is the causal connection satisfied, is it too remote, you fail at any of those hurdles, then the judge doesn't necessarily have to then go on and stand back and apply some different test in terms of the ultimate question. You don't get to a choice of the candidates if they haven't actually met the tools you're using along the way to work out are they a candidate that could be suitable to aggregate the loss. And we say, or we note, there's no challenge to the perspective to be considered that the judge identified. He sets it out at paragraphs 91 to 100 of Stonegate on page 512 onwards, and essentially holds that you're looking at it from the perspective of the policyholder. A relatively short period after loss starts to be sustained. So he says that would be March or April 2020. And you have all the knowledge which a reasonable person in the position of the insured would have at the date when you're making that judgment as to whether there is an aggregating occurrence, absent exceptional circumstances that he identifies.
Does that mean all the expert evidence is irrelevant?
Well, the judge in this case, we can see it at paragraph 149 of Stonegate. He actually said there was no real difference between the materials available at the time versus the true facts as they now appear. And there's no challenge to that finding either. It's 149 of Stonegate. And it's imported then into VE, paragraph 91 of VE. So the judge was looking at it from the perspective of the policyholder in March, April 2020, but saying that wasn't in fact materially different to the true facts as they were before him. So in those circumstances and where there is no challenge to those findings, then we say they stand. And the challenge really isn't about what the evidence shows or the judge took the wrong evidence into account. It's about how he applied the legal test to the facts and whether it's properly to be regarded or any particular candidate is properly to be regarded as a single occurrence for the purposes of aggregation or not. Can I deal with the judge's approach to the expert evidence, because it is important to have a look at that as the background to his decision. If we go back to our skeleton at paragraph 19.2, it's core bundle 8, page 76. What we've sought to do there at paragraph 19.2 is to summarise the evidence from both, that was set out in both VE and Stonegate matters. So it's summarised from paragraphs 85 to 87 of VE and paragraph 129 of Stonegate. And just to summarise, there were two separate lineages introduced separately from the animal population into the human population, known as lineage A and B. Neither of them was considered an ancestor or correspondingly a descendant of the other. There were at least 2, potentially up to 15 successful spillovers from the animal to the human population. So that's the zoonotic spillovers. Successful meaning they went on to generate sustained chains of transmission. The first spillovers probably occurred between very late October and mid-December, but more probable than not that they occurred between the 18th of November and early December, so a period of 3 weeks to a month. And to a very high degree of certainty, it was held, and you'll see the quote at the bottom of page 76, that the cases of COVID in England or the UK were not linked by a continuous chain of infection to the initial introduction in England or the UK. There were very large numbers of introductions, each genetically distinct and creating an onward chain of transmission within the UK. And then at paragraph 19.3, in relation to the Wuhan transmission outbreak arguments, the judge's reasoning there, which we've set out, was that an informed observer would have regarded the initial human infections, by which he meant the spillovers from the animal to the human population as a single occurrence, but not the outbreak of the disease in Wuhan thereafter. And I'll come back to show you the judgment in relation to that. But paragraph 19.4 on page 78, the judge's reasoning for the England-UK transmission outbreak arguments was that a causal connection was not established because of the multiple introductions that were genetically distinct, leading to onward chains of transmission. And he held that whilst it was geographically more proximate, this is at 19.4b, it was still temporarily remote from the losses. In terms of the alleged errors that are advanced by Allianz, if we go to paragraph 24 of our skeleton on page 80, Allianz's candidates 5 and 6 for Wuhan and 8 and 9 for the UK, England are about the first human-to-human transmission, or qualified by the words relevant, the first relevant human-to-human transmission, i.e. it was successful rather than dying out. The problem Allianz faced at trial and still faces is that there is was no evidence to substantiate that it was possible to identify a single first-in-time human-to-human transmission in Wuhan in circumstances where there had been between 2 and 15 animal-to-human infections, which would in turn then have led to a multiplicity of separate human-to-human transmissions from each.
Why does that matter? I mean, you can't identify it, but logically it must have happened.
Not necessarily. It could all have been simultaneous, so that there wasn't just one. You could have had 15 people infected by animals passing on, not just potentially to one person, but to many people. If you sneezed in a
all 15
crowded
of them
room.
would pass it on to one person, they'd have each passed it on to, let's say, 5 people.
Exactly.
So you get 75 separate, 75 cases. And the issue there is, well, could you possibly describe those as one occurrence?
As one occurrence. It's this idea that there is a single
Even if they
occurrence.
even if they all occurred at the same point of time, which is extremely unlikely.
Yes.
Because there must have been over a period of time,
Yes.
however short.
And transmission, it isn't linear. You don't just transmit to one person necessarily. I mean, you might just transmit to one person, but you could be transmitting to multiple people. You know, if you're in a confined space, you could infect a number of people simultaneously. You'll
Would
recall.
that be a problem for this purpose? I mean, I suppose there might be a definitional point about whether there were multiple firsts, but
Well, what we'd
might not that incident be thought of as a relevant event?
it's got to be a single occurrence under the definition. And we would dispute that there was any single occurrence. And the idea of something first in time presupposes that one person infected another and then it went from there. But there is no evidence that that was in fact the case, that there was a single first in time transmission. You'll recall the R rate, the idea that each person could transmit to multiple other people and you get this exponential growth. And the attempt was always to bring the R rate down to no more than 1, so that you didn't have that exponential growth. But that's the nature of the disease and the transmission of the disease in airborne droplets or taking it off surfaces and so on. And so we would say that there was certainly no single occurrence that an informed observer could have identified in March or April 2020, as opposed to there being a number of possibilities. So it doesn't satisfy the test for there being a single occurrence, and there was simply no basis in the evidence for.
That sounds a bit too much, in the sense that supposing there had only been one occurrence, one transmission, still nobody could have identified it in March 2020. But would that matter? I mean, even now, supposing there had been, you couldn't identify it, probably, I don't know. But
it's not about identifying it, it's just whether in fact there was ever one single occurrence that existed, as opposed to multiple.
The point you're making, as I understand it, is not this wasn't an occurrence because you can't say when it occurred.
No.
What you're saying is this wasn't an occurrence because it wasn't a single occurrence.
It-
Whenever it occurred, it was
Exactly.
75 in my example.
Exactly.
Is that the point?
That's the point. And just to look at what the judge said in Stonegate and Greg's about the initial infections, if we go to Stonegate at 143, paragraph 143, it's page 524 of the supplemental bundle tab 18. So the judge was looking at, I'm sorry, I need to go back to an earlier. He deals, for example, at paragraph 131 with the 2 to 15 successful spillovers. At 134, he concludes the first zoonotic spillovers occurred in a period between 18th of November and early December. He then deals at paragraph 142 and 143 with the initial outbreak of COVID in Wuhan. And he says at the bottom, 143, first question, for reasons I've already given, is whether an informed observer in the position of the insured making her assessment in March or April 2020 would have considered the initial outbreak to be an occurrence. In my view, such an informed observer would have considered the initial human infections to be a single occurrence. And that's a reference back to paragraph 120. Where he talks about, at the bottom of page 519, where it being traced to Hunan seafood market, where two or at most a few humans were infected with SARS-CoV-2 by infected animals at that market over a period of 1 or more days in a narrow window between late November to late December 2019. So he's found that, but then he goes on to say, on the other hand, I do not consider that such an observer would have considered that the outbreak of the disease in Wuhan thereafter, during which human-to-human transfer was established, to be a single occurrence. I consider that both these conclusions apply whether regard is had only to the knowledge which an informed observer would have had as at March, April 2020, which I consider to be the correct question, or based on the true facts as they now appear. And at 150 of Stonegate, he then goes on to deal with this as well. I do not consider the outbreak of the disease more generally, by which I mean the way it became established in the human population in Wuhan, can be regarded as a single occurrence. That was a matter of the infection of a number of individuals which will have occurred over a period of time at various places in Wuhan, a city 11 to 12 million, 4 times the size of London. In terms of area, considering the perspective, this was, in my judgment, not a single occurrence, but a number of occurrences. And then if we go to the Greg's judgment, which is at divided 19, paragraph 59, page 587.
It's the same points, isn't it?
Paragraph 59.
Yeah.
Insofar as this case is that there was a single occurrence in the zoonotic spillovers, which probably occurred in the Hunan market in Wuhan, I'm prepared to accept that they can be regarded as an occurrence. Insofar as the case relates to the wider spread of the disease in Wuhan, I do not consider that this is a single occurrence, but a number of occurrences over a period of time affecting many different individuals at various places in Wuhan. So that makes it clear that the initial human infections he's talking about are not human to human, they're animal to human. And anything beyond that, he was rejecting as potentially occurrences, but not a single occurrence, because they were multiple. And the evidence did not establish the existence of a single first-in-time transmission, human to human, that Allianz could rely on, and that was the reason for its rejection. As I've said, Allianz now appears to be...
Just to correct, the judge didn't reject the human-to-human transmissions. He made no finding in relation to human-to-human transmissions.
What Allianz now seems to be doing is to redefine its pleaded case about initial outbreak in or around November, December 2019 as meaning those zoonotic spillovers. And we see that from Allianz's skeleton at tab 7, page 52, it's paragraph 28.2.1. They say there that the judge accepted the initial human infections could be described as a single occurrence, but found that the outbreak thereafter did not amount to a single occurrence. The outbreak to which Allianz refers was that comprising the initial human infections and not anything continuing thereafter. And it appears the judge would, if it had been considered in this way, have found that the initial outbreak was a single occurrence. Now, you've seen the pleading. The initial outbreak follows the first human-to-human transmission, the first relevant human-to-human transmission. It was not mentioned in the opening note of Allianz for the preliminary issues trial. It's paragraphs 123 onwards that these were zoonotic spillovers or animal-to-human infections. It's not mentioned on the transcript. It's day 3, page 454. Onwards, tab 16, that these were zoonotic infections. It appeared as if the term initial outbreak was intended to mean something wider than the first animal-to-human transmissions. So if something else was intended, we would say the judge cannot be criticised for having failed to understand a case that had not been made clear. That was the case that was being advanced in other actions, but the case Allianz was advancing was human-to-human transmission and then, quote, initial outbreak without further elaboration, which looked as if it was subsequent to those human-to-human transmissions and something to do with the initial spread within the human population. Going back to our skeleton at tab 8, page 82, paragraph 26. We deal there with causation in relation to candidates 8 to 11, which are the England-UK initial introduction.
Yeah. So you're moving on from occurrence.
I'm moving on from occurrence.
So I think the one that Mr. Doherty was emphasising this morning was 6, the first relevant human-to-human transmission.
Yes.
And there, that's encompassed by your wider point that you can't identify any particular human-to-human transmission.
It is. We do deal in the, perhaps I can deal with it now, in the respondent's notice.
Well, your point really is, and it's that is that you, on the basis of the expert evidence, it wasn't possible to isolate there being a first relevant human-to-human transmission.
That's correct.
As opposed to a whole load of human-to-human transmissions at or about the same time,
Yes.
which may all in one sense have been relevant, but which couldn't be one occurrence.
Well, the evidence was that 70% would die out, so they wouldn't all have been relevant in
Yeah.
terms of being successful.
But if we assume that the 30% of the relevant ones, it's not one, and
No.
and it's difficult to say
It's first in time.
it's first in time.
Yes. Could I just, while I'm here, rather than coming back to it, because we do add to the reasons which we say the judge could have relied on in our respondent's notice. It's summarised at paragraph 33 of our skeleton, page 85 of the core bundle. And this was evidence that was common ground, it wasn't challenged, which was, as I said, that this isn't relevant to the relevant human-to-human transmission. The first one could have resulted in just one dead-end infection or a small and transient cluster of cases that quickly went extinct. 70% were predicted to go extinct and survive for an average of only 8 days. Professor Pybus also gave evidence that all infections were not causally connected to just one human-to-human transmission. And Professor Hiscox's evidence also included the statement in my view, the global pandemic is probably not directly linked to a single animal to human or indeed human to human transmission of SARS-CoV-2. So the evidence was that there was no single occurrence, and there was no causative link back to any alleged single occurrence or single transmission. And that was unchallenged. And you'll have seen from the judgments that the parties in each action saw the evidence and submissions and had the opportunity to comment. VE on Greggs and Stonegate on VE and Greggs and so on. So that's recorded in the judgments. And Professor Hiscox did give evidence in the Stonegate case, although the case about human-to-human transmissions was unique to Allianz. That was not part of the Stonegate insurers case. So just going back now to paragraph 26, I was just going to deal with the causation element and the judge's findings in relation to candidates 8 to 11, which is the England-UK first transmission stroke initial introduction. And the evidence is summarised by the judge, and we've set it out there, provided no support for the finding of a causal connection of any strength between those first transmissions or introductions in the UK, England, and VE's losses, given the number of them. And those were just successful introductions. And it's probably unsurprising in light of that that the Stonegate insurers didn't press that at trial. Allianz did, and they press it on appeal, but that was the evidence before the court. And we say at paragraph 26.3, and this is the Manona Friends case, that the judge's finding was inconsistent with the FCA test case and the Supreme Court's finding in that case about the concurrent effect of all of the disease cases together. But if what Allianz was contending was that the occurrence was the initial or the first transmission or introduction, you have to assess its causative impact between that transmission or introduction and the losses in isolation from, rather than concurrently with all of the other cases. And so we say that Arch doesn't help them in that regard.
Well, it's just not an aggregation case.
This is an aggregation case, that was causation.
They weren't considering whether or not the finding of causation that they made
Correct.
would mean there was only one occurrence.
That's right.
It would be a slightly surprising conclusion.
Yes.
I suppose it's possible.
Yes. We would say it just doesn't apply when you're looking at aggregation. If what is being said is it was the first transmission, that is the alleged candidate that is relevant when you're looking at does it satisfy the causal test, and then you're linking to VE's losses or any other policyholder's losses to try to identify whether that causal connection is satisfied. And we say the judge was entirely right to say that it just wasn't. There was no causation, evidence of any impact. And you can't just amalgamate all the disease cases together for that purpose. Remoteness, paragraph 27 of our skeleton. As I said, I don't propose to go through it all, just to highlight some points from it. Paragraph 28.1, the judge disregarded earlier occurrences for nearer occurrences in the sense of UK government action being the nearest. It's not said it was wrong to do that in principle. It said you didn't pay enough attention to the earlier occurrences as being single occurrences. Paragraph 28.2, the judge didn't turn remoteness into a key controlling factor in an inappropriate way. He appropriately used remoteness as a backstop against the otherwise overreaching effect of the establishment of a causal connection, and he was entitled to do so. Using remoteness in that way doesn't mean it's impermissibly being treated as a key controlling factor. It's playing an appropriate role in an appropriate case for its application. And then at paragraph 28.3, the question of whether an earlier occurrence is to be excluded as irrelevant, it's not in a causal sense as a possible explanation for the loss, but it's whether it was irrelevant as an aggregating event. And then at paragraph 28.4, the judge didn't fail to have regard to the matters that Allianz set out, and indeed specifically considered the ease of communication of the virus in a globalized world. And we can see that, I won't go to it specifically, but it's referred to there at Stonegate 154. I've dealt with the respondent's notice so far as the Wuhan transmission outbreak arguments are concerned. I just wanted to deal with the further point in our respondent's notice, but briefly, which is that Allianz appeared, at least, to be relying on the reference to outbreak in the policy wording in the schedule as supporting its case on aggregation, i.e. initial outbreak can be a single occurrence with a causative link not too remote, etc. And we can see in the schedule, it's in the supplementary bundle at tab 5, volume 1, tab 5, at page 96. This is the endorsement where it appears. It's about 4 lines up from the bottom. I think my learned friend took you to the bit that he said had not been materially amended by this endorsement, but this is the endorsement itself. 2, 3, sorry, it's 5 lines up. Where it says, where a disease occurs and is subsequently classified under the Health Protection Regulations 2010, such disease will be deemed to be notifiable from its initial outbreak. Now, we had understood that what was being said by that is of significance, in meaning that an outbreak is a single occurrence for the purposes of the policy. And that's why we made reference to the New World Harbourview case, which provides the rationale for inserting that into the policy, because that had held that with a notifiable disease, loss was only covered from when the disease became notifiable, even though loss had been happening prior to the disease being declared to be notifiable. My Lord the Chancellor remembers this from the test case, that clearly policyholders were not delighted with that outcome, and so Marsh, which was putting together the Marsh Resilience Form, was seeking to remedy that and ensure that loss would actually date from when the initial outbreak started, i.e. when loss would start to become being suffered, rather than from the date of notifiability. And so we would say the word outbreak doesn't help at all with whether it was intended to be a single occurrence for aggregation purposes. What is now being said is that it's simply an indication that the policy is looking at disease generally, outside the vicinity or outside the period of insurance. And it's being said, in effect, that this helps with that. And I just wanted to deal with my learned friend's argument that what the single occurrence was effectively the emergence of a new virus in Wuhan. And that's what's at its core. And all of these ways of candidates for aggregation are just proxies for that. But what we would say is that that is actually looking at an original cause, an originating cause. It's not looking at a single occurrence. And albeit it wasn't in the context of aggregation, if one looks at what the Supreme Court said in the test case, it's in volume 1 of the authorities bundle, tab 12, page 381, paragraph 240. You'll see there, it is the second last sentence, in the present case, the originating cause of any local occurrence of disease is the global COVID-19 pandemic. My learned friend took you to the discussion of individual cases being occurrences and possibly having a single occurrence where, or an occurrence where you had members of a household being infected on the same date by the same person. But it was clear from 240 that the pandemic itself was regarded as an originating cause. And that, when my learned friend is talking about, well, the policy covers the pandemic, leaving aside that that wasn't their case in the FCA test case, but it is now established that it covers pandemic diseases. What he's referring to, this emergence of a new virus in Wuhan, is originating cause, not an event. It's the pandemic that is the cause. So it's not a single occurrence. And as we saw from the wording in the schedule, go back to it, the SBIL wording, in the policy itself, it's tab 1 of the supplementary bundle, page 33. We can see that the SBIL for business interruption loss at 1 is any amounts that are all business interruption loss, business interruption costs and expenses, and any amounts payable under extensions that arise from, are attributable to, or are in connection with a single occurrence, except in respect of cyber events, earthquakes, floods and storms. And then we see a distinction when we get to cyber events, because that is by reference to, again, the same words, arise from, attributable to, or are in connection with a single originating cause. So there's a clear distinction in the policy between single occurrence, which is synonymous with event, and originating cause, which applies for cyber events, but not otherwise. And then with earthquakes, floods and storms, you've already looked at that and the fact that it has an hours clause. That is occurrence-based, but with a limit in terms of time. So this redefinition of the candidates before the judge as some overarching novel coronavirus emerging from Wuhan as proxy for everything else, we would submit just doesn't work, because one is in originating cause territory, you're not in single event territory, and the fact that that may have been the beginning of it all really doesn't help Allianz on aggregation. If you just bear with me a second. My lords, those were my submissions in response to the Allianz appeal. I now need to open my own appeal. I'm just conscious of the time. It's 4:05. I can start that now, or I can do it in the morning.
Yes, I think start now, please. I don't know what is proposed. I mean, I haven't asked my colleagues if we can sit till 4:30 or not. I mean, we could sit till 4:30 if that helps.
We can do that. I believe I can do it in the hour and a half I have allocated in the morning. So it's entirely your choice. I'm very happy to start.
You do 10 minutes now. And
10 minutes now? Okay. So my lords, I'm now going to turn to various Eateries appeal, which has 3 grounds, one of which has been given permission by the judge, and 2 of which require permission to appeal. They all involve issues of construction. The legal issues are, we believe, common ground, although we've set out some points of emphasis in our appeal skeleton, which is at tab 9 and page 94.
Yeah.
So I don't intend to dwell on this. The test set out in Arch about the question is what the language would have been understood to mean, not to an insurance or pedantic lawyer, subjecting it to minute textual analysis, but to an ordinary policyholder who's read the policy conscientiously, albeit potentially advised by a broker. And this was a policy that was sold to a range of insureds, including SMEs. as is accepted. Second, the search for the reasonable expectation of the parties involves an approach which is neither overly abstract nor technical, but rather concerned with identifying what Lord Steyn, writing extrajudicially, described as community values, contemporary standards, not of moral philosophers, but of ordinary right-thinking people. And then third, and this has been referred to already, in the specific context of business interruption insurance, it's a legitimate approach to construction to have regard to the extent to which construction enables or disables the insured from establishing quickly and easily the matters relevant to its claim for indemnity. And the judge agreed with that proposition from the Australian case of Marrickville at Stonegate, paragraph 98. So if I turn first to our first ground for premises aggregation, which is addressed at section C, paragraphs 13 onwards of the appeal skeleton. So that's tab 9, page 95 onwards. Now, this issue arises in the event that these losses fall to be aggregated and are subject to the £2.5 million limit in respect of the disease clause or the enforced closure clause, as the judge held was in principle possible in respect of some relevant occurrences. And we can see that from his answer to preliminary issue 16, which is at tab 14, page 236.
Yeah. Yeah.
I won't read it out, it's quite a long paragraph, but he identifies there the single occurrences which are not too remote for the purposes of the SBIL clause and around which, subject to proof, these losses could aggregate, starting with the government decision on the 16th of March during a COBRA meeting and going on from there, including the imposition of the second lockdown. Paragraph 17.
He's found, hasn't he, that I mean, the first three affect your policy directly, or potentially affect your policy directly, and the other two don't directly because they're occurrences which post-date the period of insurance.
Yes, but he does find that the cases during the period of insurance have a continuing effect. So, for example, in October, when the tiered system is introduced, that is causatively, any loss from that is causatively related to cases of disease during the period of insurance. And the enforced closure, the early closing in September, again, subject to the appeal point, is continuing beyond the policy end.
I imagine that's why the insurers are pursuing their ground too.
Yes, it will be. And paragraph 17, aggregation by SBIL is not on a per insured location basis. I'm calling it per premises, but meaning the same thing. And the judge deals with that in his judgment at paragraph 103. We can go to that. I'll just invite you to read paragraph 103 if you haven't already. And then the judge addressed the same argument which was also run in Stonegate, in the Stonegate judgment.
Yeah.
For completeness, I'd invite you to read those passages too. It's Supplementary Bundle 2, tab 18, page 516, paragraphs 107 to 108. He also refers to this issue at paragraph 180 on page 532. And then we've summarised the 4 reasons that the judge gave across those paragraphs. Paragraph 14 of our skeleton, tab 9, page 95. And you'll see that there was no support for this in the definition of single business interruption as the aggregating provision. The limit of liability per SBIL and total value provisions were only consistent with the possibility that there can be an SBIL in respect of different losses derived from different insured locations. That the wording of the retention was a pointer that an SBIL can affect more than one insured location, and that in circumstances where the policy was not a composite one, the relevant perspective, at any rate in the case of Stonegate, was that of the policyholder as operator of multiple premises. And our submissions as to why the learned judge erred in not holding that aggregation by SBIL is on a per premises or per insured location basis of these, noting he read across his conclusions from the Stonegate action rather than specifically addressing the distinct position in VE.
Do you want to deal with those in the morning?
I'd be very happy to, as I said, I'm at your disposal. I think we've got no difficulty at all in terms of time. We will definitely
Plenty of
complete
time.
tomorrow.
The impression I have is we have plenty of time. Yes?
Yeah, yes, my lord.
Thought you were going to commit yourself for a moment.
No, my lord.
Okay, so 10:30 in the morning, thank you very much.
All right.